right, you got a question, I got an answer, and something we do. You call this number, and I speak with you and give you immigration advice. Let's go to Ashton in Orange, New Jersey. Ashton.
Hey, good night. How are you guys doing?
Good. How you doing?
I'm doing awesome. I have two questions. I don't know if you can spare me two questions.
Go ahead.
Okay, first question is, I applied for my brother about 11 years ago. Upon the application, his children were under 21, and they're all are dependent to him. Currently, his children are over 21, and is the children eligible to come with him when they move to the United States and be able to get a green card? Question is, in the Biden administration bill that he passes on immigration, does it allow my family member my brother to move to the United States and live with me while he waits for his green card?
Okay, so let me ask you on question one about the derivative children. When did you file for your brother?
Brother, in late 2010.
Okay.
Late 2009, 2010.
All right, and that petition got approved, right?
Yes, the petition was approved, and it's currently at the National Visa Center waiting on an invoice number for my brother and his family.
When did the petition get approved?
In 2015.
So it took approximately 5 or 6 years, I guess, to get approved.
I think it was approved in 2015 when they sent them out a duplicate notice.
So it was about how long did it take to get approved? I'm trying to figure out. So you filed in 2009.
Around 5 to 6 years.
5 to 6 years. Okay.
Yes.
So right now they are up to October 22nd, 2006 for brothers and sisters. You filed in 2010. I assume that in the next year or two, your brother it's going to move pretty fast. That's my thinking.
Okay, in the next year or two, they will be able to move and live with me.
No, I said it'll move fast in the next year or two, and hopefully that priority date will be reached.
Okay.
Now, let me tell you how you calculate whether or not the children are going to be derivatives under, it's a math problem, okay? Whether the children will be derivatives under that case. You take the difference in time between the time that the case was filed to the time when the case got approved. So in your case, in your particular example, you filed in 2009, 2010, it got approved in 2015. Let's call it 5 years. It's probably more than 5 years, but let's call it 5 years. You get to add those 5 years it took that I-130 to get approved onto the child's 21st birthday. So now the child doesn't age out at 21, the child would age out at 26. And then you say, what is the date when that child's age gets frozen? That child's age gets frozen when you pay the filing fees at the National Visa Center, and the National Visa Center accepts them. You got to wait for that fee bill, and the priority date is current. If those two things happen before the child reaches that magic age of the difference
26.
between filing 26, 27, you actually got to do the math on the I-130.
Okay.
Then that age gets frozen, they're included, they get to come. So the answer is, will they come or not? You don't know until you know when the priority dates are going to be reached. So the answer is, we don't know yet, because the calculation still is going on. Next thing, will they be able to come on Biden? No. Right now, the V visa, which is what Biden put in for the U.S. Citizenship Act of 2021, is only for unmarried and married children of residents and citizens, not for brothers and sisters.
Oh, makes sense. Makes sense.
All right. So right now, my answer is hang in there. We'll see what happens.
Okay. Thank you so much.
You're welcome.
Thank you. Thank you.
Let's go to Ola in Chicago. Ola. Hi, Ola. Hi, Ola. Ola.
Hello?
How are you?
Can you hear me?
I do. How are you?
Okay. Good. All right, sir. I have a question. My question is this: regards to the marriage and the 3 years of marriage. So I have a marriage that's going to be 3 years in June, and I have a temporary, the 2-year green card, which I got last year, May.
Right.
So am I due for the N400 now?
No. It's not based on the number of years you're married. It's based on the number of years you had a green card. So what the law says is that if you've had a green card for 3 years, whether in conditional or in permanent status, and during that 3 years you were in a bona fide marriage to a U.S. citizen, you can file citizenship. So you have to wait 2 years, 9 months, 3 days from the time you got your green card, provided you're in a bona fide relationship. Thanks for watching. For more Bradshaw Live, like and subscribe to our YouTube channel.